Michael Cohen here, Dallas Elder Law Attorney. Today we're going to talk a little bit about transfer on death deeds. This is different than a ladybird deed. A transfer on death deed is a deed that says who your property goes to after you die. The whole idea of our government in allowing these transfer on death deeds is a lot of different people were not having wills, and which created a lot of different title issues because you have children, so and so else has children, etc., and it goes down the line. Without a will, then it gets to be title issues. Well, but transfer on death deeds don't come without some issues. Under the Texas law, the Texas Estates Code, there could be 2 years for a creditor on a transfer on death deed to come out of the woodworks to make a claim. So a lot of different title companies will not issue good title until 2 years have passed. So if you had a property that had a lien on it, like a deed of trust, a mortgage, and you said, oh gee, I have to make those mortgage payments, the child could be the beneficiary, let's say, of that property subject to the mortgage, but they can't make the mortgage payments and they can't sell the property because the title company won't issue good title because the Estates Code allows 2 years for creditors to come out of the woodworks. Besides the bank, there could be other creditors out there. So the Texas transfer on death deeds could have a problem there. Another thing is sometimes people sign a will afterwards. Now the transfer on death deed supersedes the will, but it often leads to confusion, potential litigation. Another thing is if the transfer on death deed is not recorded with the county clerk where the property is located, then it's as if it didn't occur, and you would still have to probate the will if you had a will to begin with. If you didn't have a will to begin with, then you have to have a costly heirship determination. So don't think of this as the only thing you have to do. Usually when we do a will and you have a transfer on death deed or a ladybird deed too, either way we make reference to that in the will so that there's no doubt about it if you had to probate. Another thing is if you got divorced, it doesn't automatically cancel the deed. Many different types of documents, there's a cancellation automatically upon divorce. So if you had a will that says all to my wife, well, the will that wife wouldn't get everything when you die because of the divorce. If you had a power of attorney or where you named your spouse as your agent and y'all got divorced, well, then they no longer have the authority. If you had different beneficiary designations, also it could be terminated as a matter of law. However, with a transfer on death deed, you have to record or cancel the transfer on death deed before you die if you were getting divorced. So it's a little bit different situation on a divorce. Another thing is that there's no warranties of title. On a general warranty deed, usually for a ladybird deed, you do a general or a special warranty deed, which goes back through time, Texas land grants, and you could show the title if there was any kind of glitches. But on a transfer on death deed, there are no warranties of title. And the person who's the beneficiary has to survive at least 5 days. If that person dies before you, it's like no deed occurred at all. Also, you can't name a class of beneficiaries. I can't say to all my children. You have to actually name the children for that, or whoever it is that you want it to be, as the beneficiary in the deed. Now, there's some good things about a transfer on death deed. You could have contingent beneficiaries. If so-and-so is my beneficiary, but if they die, it goes to so-and-so. You could do that on a transfer on death deed. It's very simple to do. It does avoid probate. It does avoid Medicaid estate recovery for those who are on long-term care Medicaid, where the government has a right to make a claim against the property, usually your homestead after your death. This does, since it goes outside of probate, in other words, it doesn't have to be transferred by your will, it's going by just the deed, then it avoids a successful claim by the government. Of course, you'd need a death certificate. All you have to do is go to the county clerk or the appraisal district and show them the death certificate and the deed. Same thing on ladybird deeds that we've talked about on another one of these segments. And you would do the same thing, just show the deed and the death certificate, and it just goes the way you would like. So it's pretty simple with that, and you don't have to go to court. You avoid probate. So there are some good things about transfer on death deeds, but there are lots of bad things, and everybody's situation should be examined. Sometimes it's better to have a transfer on death deed. Sometimes it's better to have a ladybird deed. So it depends on what your facts are. You should probably have it reviewed before you decide to do anything. Thank you for your time.